Und damit kommen wir zu einem Talk, der ein Thema berührt, mit dem die eine oder andere hier schon mal Erfahrung hatte. Wie der Zufall es will, bin ich vor einigen Jahren zufällig in der Interpol-Falldatei für Cybercrime gelandet. Fun Fact, ich kann gar nicht hacken.
Fun fact, I can't hack at all. It was sufficient that I made a protest website. But I'm not alone with this problem. There's a lot of people who do responsible and ethical hacking, find security vulnerabilities, want to close them, and want to have them closed, and then wonder, is this a criminal act? Do I risk prosecution from the company who would like to hush it up, that they've got a vulnerability, or from the authorities? And this is what our two speakers are talking about. Their talk takes a while, but is it gonna get good? Modernizing computer criminal law. Florian Handke is a PhD candidate at the Helmholtz Institute for Information Security, and he's got a very solid background as a pen tester. And he's talking with Professor Dr. Dennis Kenji Kipke. He is a scientific director at the Cyber Intelligence Institute in Frankfurt. Please give them a warm welcome.
Hello. Yeah, thank you so much for these nice words. Thank you for letting us be here. And I'm so happy that so many people are interested in our talk, in our lecture about the modernization of computer criminal law. Before we start to dive in deep into the topic, let's have a look at our plan. The Federal Ministry for Justice finally put up a proposal for a long-needed reform of computer criminal law, which should have been changed for so long, but this year the proposal finally came, so we thought, okay, there will be lots of people here interested in this topic, so let's put up a proposal for presentation, and we were delighted that our presentation was accepted. And then we thought, okay, what could we tell you? We drafted a concept. Well, and then the coalition collapsed, and we sat there like that and thought, okay, great, now we can restart everything. That's what we did. So I will tell you a little bit about the background of computer criminal law. Where does it come from? Where do the problems come from we have at the moment? What are the problems we currently have? And what is this proposal for reform actually, and how will things continue? What do we know yet?
Who we are? My name is Florian Handke. We have been introduced. Thanks very much. I'm a PhD candidate at the CISPA, Helmholtz Center for Information Security, and I'm mostly involved in web security and web security subjects, and that's how I got into this legal frame. I'm here with Dennis. Hi, welcome here. I'm Dennis Kipke. I'm the research director at the Cyber Intelligence Institute, as you can see, and I'm a professor for IT security law in Wiesbaden, and I deal a lot with IT security law. Okay, let's start with the subject. It took a while. What's the origin of the computer criminal law? It's pretty old, actually. The first laws were passed in 1986. For example, paragraph 202A against data espionage and 303A, B and C against data manipulation, because they started to see there were new developments in economics, and so that necessitated more electronic data processing, and that brought forth new kinds of crime. And to counter this, they thought, okay, we're going to need to pass a law against white-collar crime. You see, it's been a long while. I wasn't born yet. And when researching this, the word internet only entered into the Duden 10 years later, and so they weren't thinking of everything that's happening here in our modern times today. But Dennis is going to talk about this later. And as time passed on, cybercrime became ever more relevant, nationally and internationally. So 2001, there was a convention in Budapest, and they passed the Budapest Convention on Cybercrime. It's where they agreed on some ground rules for cybercrime, and these ground rules are also reflected in German cybercriminal law. And there was the Article 6 in this convention, which prohibited procuring, distributing, etc., of hacking tools, and penalizes criminal hacking. This should be familiar to some of us here. But there's also explicitly in there that tools that are not used for criminal deeds, so for like legal pen testing or security research, are not illegal. And on the basis of this convention, the 2007 amendments were passed to our cybercriminal law, and there were some new laws added, like paragraph 202p in the Penal Code, or 202c, which is the hacker paragraph, our pendant to the Article 6 from the Budapest Convention. Our 202c has a pretty broad scope, as we're going to see later. So there were constitutional complaints against this from the Chaos Computer Club and others. They brought forth lawsuits, and in 2009, our Constitutional Court heard this, and they realized, no, they don't want to change the wording of the law, because it's clear that this 202c is only based on tools and is only dealing with tools that are used for criminal deeds. It's a kind of an undercurrent in their decision, but me, as somebody who knows IT security, should understand the laws without having to get a law degree. Oh well, but there's still this paragraph in existence. And now, Dennis, how did it go on?
Well, not a lot has happened really. If you look at the timeline since 2000, from 2007 to 2009, not a lot happened. And some of the things that made us propose this talk is that in 2021, in December, a reform of computer criminal law was first mentioned in the coalition treaty of the then red, green, yellow government, so Social Democrat, Green and Liberals. Nothing much happened since then, but in June 2023 and October, 2 symposiums were held regarding the reform of computer criminal law. This was in the Justice Ministry with people from research, from civil society, politics, from ministries were invited to see what the pain points would be in computer criminal law, what the issues were that what should be changed. And then they took a bit of time. There was a draft from the ministry that was put forward on the 4th of November 2024, so a very short time ago, and that was then published. And the timeline for commenting on this, the deadline has passed now too. So far so good, but the question is to understand how computer criminal law works. We first have to understand how criminal law in itself works. So a very short crash course, a kind of a law lecture on how you can kind of understand what computer criminal law does. You can see quite clearly what they have to do. There's this 3-step of the crime. The first issue is the actual crime. What is the objective deed? What is actually fulfilled through my actions? And that's the first thing you have to check. And then the question is, was that intentional or was that with negligence? So you have to understand that you actually violated the law. That's the second step. And you can then have exceptions, interjections, and especially in the region of pen testing, penetrating tests, this is important. Penetration tests done professionally are on the basis of an agreement, and that leads to the fact that you haven't actually been doing a criminal deed, and the question is, if a computer system is out there insecure, not just for the operators but for the society in general, would this be a kind of emergency action? So at the end, you always have to ask if this potential culprit has done the deed in violation of the law. Was he actually culpable? Can this be laid on him? And if someone has, for example, put himself in a state where they can check systems for their security, but you could still say, well, you have to look at the state they had before they were kind of intoxicated or something. And if someone is acting intentionally, that is a condition that criminal law includes quite clearly. Only intentional and negligence actions are culpable or penalizable. So what is the core of criminal law? You've talked about the hacker paragraph. Florian, this is an important norm, but not the single one. And if you look at a few more things that criminal code is about, you can distinguish a core and a margin of criminal law. And I've listed the main, from the core of the law, the main paragraphs. So spying on data, capturing data, hacking, and access to data, which of course is always the case in these, but this is mainly about intentional actions. Then you have 303A and 303B in the German criminal law. These are manipulations of data and sabotage. And next to that, you have the marginal law, which means that there are rules in law that make penalizable some actions, but they're not actually part of criminal law. So you have the ban on eavesdropping, the Digital Services Data Protection Law in telecommunications. Very nice title. Everyone likes this. You have the disclosure of business secrets, or you have intellectual property law. And as an IT security researcher, you may gain access to business secrets. And if you are acting as a security researcher, the question also is, when does the German law actually apply? And it's quite easy to say that the German law that which Professor Modowski wrote down is applicable if the person has acted in Germany and or the effect that is relevant in criminal law was taking place in Germany. Now, looking at one of these paragraphs, especially on 202A and B and C, C being the hacker paragraph, is what we're going to look at. In 202A, it's quite clearly formulated. Data espionage, you can look at the deeds that are in the law. They are kind of like formulas or equations. You have certain variables which are then set, assigned certain values, and if then you have something like 1 and 0, and if you get to a result which tells you whether you are actually penalizable or not. And what is important is the objective deeds. In section 1, you have whoever, without being authorized to do so, obtains access by circumventing the access protection or to themselves or another, data which were not intended for them, incurs a penalty of imprisonment for a term not exceeding 3 years or a fine. So you can see you have to be unauthorized, you have to have access to data that are not intended for you, and there has to be protections that you overcome. What are data? This is defined in law. Data, for the purposes of subsection 1, are those which are stored or transmitted electronically, magnetically, or otherwise in a manner which is not immediately perceptible or transmitted. Yeah, so this is kind of a broad term. If you look at 202b,
ganz ähnlich formuliert, kann man relativ zügig fest.
This is quite a similar phrasing, as you can see. Whoever, without being authorized to do so, intercepts data which are not intended for them, either for themselves or another, from a non-public data transmission or from electromagnetic broadcast from a data processing facility, these are side channel attacks, will be penalized with a prison term or fines. And 202C talks about acts preparatory to data espionage and phishing. This is especially virulent, and we're going to talk about this later, because this is about the question of when do I, as an IT criminal researcher, when am I doing criminal acts? And this is very wishy-washy. Whoever prepares the commission of an offense under Section 202A or 202B by producing, acquiring for themselves or another, selling, supplying to another, disseminating or making available in another way, passwords or security codes which provide access to data, computer programs for the purpose of the commission of such an offense, incurs a penalty of imprisonment for a term not exceeding 2 years or a fine. This is, again, a very, very wide phrasing. And the question we need to ask ourselves is, what does this mean for us, and what does this mean in criminal proceedings? The threat does not end at this point for IT researchers, because on top of the criminal acts, there's also in criminal proceeding and investigations. There's internet patrols. They are generally permissible. Passive observation of activities in public data networks. The authorities are authorized to do this at any time. Seizure of data and searches at the accused homes. And for us, this case is very relevant from the Criminal Procedure Code. Examination of identity papers and electronic storage media. This is a little house search. So it's possible for the authorities to not just seize storage mediums, but they also may access the contents. And this contains also things in cloud storage and other online security. And the problem with this is that then a mere suspicion is sufficient. The mere suspicion that a crime may possibly be committed in the future is sufficient for the prosecution. And this is a very, very low threshold that exists in criminal law and in criminal proceedings. And if we're to sum this up now, and we're seeing pretty quickly there's a lot of reasons because why we need to reform German IT computer law. The definition of danger. The acts of white hats are very often considered illegal and may be prosecuted. And why is this? We have seen these are very broad definitions. Computer programs are included, as well as other files on hard drives. And there's also IT security researchers do not have authorized access to these data because, as the criminal law says, whoever saved the data is independent of hardware ownership, the one who is authorized to access these data. It's called Scriptura-Act, and this is relevant for source code or compiling programs. And furthermore, and that's from jurisdiction, so what secures data is not just passwords or write-read permissions, and also, and this makes it even harder, that I, as an IT security researcher, don't even need to know what's in the data. The fact that I breached the system is sufficient so that there's a danger for the entire system, and this makes possible that I don't just violate criminal law, but also from these marginal laws, as told before, business secrets, etc. And there's also the problem that in many cases there was no prior authorization or an agreement to research into this. That's the first point. The second point is legal uncertainty, and we saw this. And here, unclarity and contradictions in the judicial interpretation, and laypersons don't understand this law. If you look at these laws, it's not really easy to understand for a layperson. The first person is you can say, IT security gap, we have a permanent emergency for many people, and this endangers a lot of
We have the problem of dual-use tools, which especially in the hacker paragraph 202C is relevant, because many tools are not just for furthering computer security, but can also be used to weaken security. In paragraph 202C, we have no indication which kind of program would be relevant in terms of criminal law. There is jurisdiction from the courts, which says that in addition to the objective possibility of a tool, the intention has to be clear to use it in a damaging way. This is not included in the law. So as a layperson, you have no way of coming to that conclusion. And also, you have that the computer criminal law facts have to be pursued on the action of the prosecution authorities. So it has to be said by the authorities that there is a public interest in pursuing these actions. And what I also found most interesting almost, so it's the last not least, you have a case from the Regional Court of Jülich in Western Germany, and this was a kind of example case, and it said that reading out the password after decompiling the source code is the actual circumvention of a protection. So you can quite clearly see what protection can mean. And the court said that a broad understanding of circumventing has to be used, and this is oriented on a layperson's understanding. So any kind of technical property can be turned into an access protection. And what Florian said in his introduction is this issue that this law is quite aged and it hasn't been reformed for quite a while. So again, we are not reflecting the state of digitalization or the current state of technology or the security needs of today. And this is because a report about CVD policies have been made part of current EU regulations, and it says there we need an easier way for coordinated disclosure of vulnerabilities, and this is not reflected in German computer security law. And you can see that you have 1998 on the one hand in the German law, and then the new version from 2007, hardly anything was changed. The circumvention of protections was inserted, but this was in jurisdiction anyway. So basically, you can say that German criminal law here is at the state of 1987. So there are good reasons, many good reasons for a reform of this. CCC itself has submitted a report, a white paper, to the German Constitutional Court. There's a white paper in Germany from a multidisciplinary perspective, and at the end, a security researcher will have to consider: am I going to report and incur a risk on myself, or do I let a risk to security remain? And this was quite well summarized by the ministry's draft from the Justice Ministry. And there's this one sentence here: it has to be prevented that criminal law chills people or deters people from actions that occur in the interest of society. And this is particularly relevant for computer criminal law. And yes, the applause is quite important here. Thank you. The question is whether you can actually applaud, because the political intention is there, quite clear to see. And we can look at that a bit further. You know some of the elements of the crime now. It's about espionage on data. And now you have to have this unauthorized term, this word unauthorized, which occurs in 202A and 202B, and in the paragraph 203A on data alterations or manipulation. And what has been done regarding these three regulations, these three acts, is they left it more or less as it was, but they added a few criteria that would say when an action is not unauthorized, when, for example, it is with the intention of determining a vulnerability or another security risk of an information technological system, and to inform the responsible people for the information technological system or the German Agency for Security in IT, and whether the action, second condition, is required to determine this vulnerability. And this was then kind of transferred to the other paragraphs where they just cite these same new sections in the previous paragraph. So this is the whole change, basically. Let's now look at what other countries are doing. The scientific service for the German Parliament has fortunately put an expertise together, and they analyzed the, in quotes, ethical hacking practices in other states in law. I dug out the example of the Netherlands, and the arguments are roughly the same. Authorities, institutions are encouraged to establish guidelines on ethical hacking, on reporting. Actions of an ethical hacker that are reported by an organization without regulations, this will not automatically be regarded as the action of a suspect. And it will be investigated whether there is a social interest, and the requirement for subsidiarity was also respected, is also another criterion. So here we have the good wishes. Now let's look at the reality, and you can say what is positive is we have a criterion that excludes the applicability of the facts of the deed. It has to be, the action has to be with the intention of determining a vulnerability, and this vulnerability then has to be reported in a responsible way. And another criterion is that the action was required to determine that there is a vulnerability. And I'm going to hand over to Florian here, because you will surely have something to say on that. First, I'm going to ask the requirement of the action. What is required? Where are the limits? And from my research that I did with many other experts and have had these discussions, it was obvious to me that it's not very clear what is actually a required action to prove that there is a vulnerability. Think of an SQL insertion, for example. Is it enough to make the database just calculate 1 + 1 with a select 1 + 1 and get a 2 in response? Or should I go the safe way and dump the whole database? Select 1 + 1 could be executed by a very strange code logic on the server side, returning this number 2, and I will then be reporting a false positive to the developers. And I don't want to stress them unnecessarily, of course. On the other hand, the whole database, dumping the whole database, is not really in accordance with hacker ethics. I don't want to be delving in someone else's data. So would I extract some records, 1 or 2? Where is the limit? Or what about if I see from the database version, maybe there is a remote code execution possible because this version is vulnerable. Should I then run this code execution? Is it required to then run code on the developers or operators' machines? So the requirement is not very well defined here, and it's quite hard to define this. And at the end, we will have to kind of rely on the goodness of the judges. Can we trust that? Until people have used the law in the past in different ways, and I am not quite certain that we can have this trust. Then the law says that vulnerabilities have to be reported, and yes, I think that is quite a good thing, because every vulnerability that you find should be reported. So I'm not going to criticize anything here, but just do a small excursion about the way responsible disclosure works. What do you do? It's quite short. I'm just going to refer to a talk by Zerforschung, where this whole issue was quite deeply discussed, and there's, I think, going to be another talk on that same issue in this Congress. So how does it all work? You have to find the vulnerability first, and at first this is a happy experience. The adrenaline is running. And then you should reproduce, because it could well be that this was just a random event or something was not quite understood. So you have to reproduce the vulnerability, then you have to write it down. You have to note what has been found, what can be reproduced, and what is the impact of the whole thing. And maybe if you have recommendations, what can be fixed. And there are various ways of reporting that. You could send it to the manufacturer. Maybe there is a security.txt on the website if the manufacturer has that. Not many people have that. There are bug report platforms, but you have to be careful here about non-disclosure agreements and such. You don't really want to sign those. Or maybe you can report anonymously via the CCC, perhaps. They have an email address. The German agency on IT security has ways. The talk I'm referring to has more information on that. Then, hopefully, the vulnerability will be fixed. And again, I'll refer to the other talk now. But hopefully, it will be fixed. And then you are allowed to publish on the vulnerability. So much about that, but let's go back to the draft law and the term of intention.
So the draft says you have to act with the intention of finding a vulnerability. Now I'm wondering if the police comes knocking, yo, we're going to search your home. How do I prove my good intentions? And how do we differentiate this from illegal actions? Do I just document everything? What do I need to do? Do I just document everything step by step, very minutely? What do I even document? I can't just document every step, every action I do on my computer. I mean, I sit on my laptop the entire day. I can't write a protocol at the same time. And now I don't know, I access this URL and that. So what exactly do you need to document? Another consideration is reporting this in advance if you are intending to do certain hacks, to give the other side a heads up. But if you report this to an authority, how is this about privacy? Or often you find things on accident. So this prior reporting is, for me as an IT security researcher, if I am going to look into a certain subject matter, but the private white hat is not going to be this planned. Like, for example, here, let's look at this. Who of you has itchy fingers to change the 1338 to a 1337? So if I see this, I change the ID at once, and suddenly I see other people's party pictures or another dog to which I shouldn't have any access. And at this moment, I wasn't thinking, okay, I'm going to change the ID, and then I'm going to report it, or I'm going to document it straight away. So what about these accidental fines? Ultimately, we have to rely on the judge again, who we need to convince that we did not act illegally. And this really needs an adjustment in the law and clearer rules. And how is it now? The Judicial Ministry did in the referent draft state that acts for the common good should not be discouraged. Did they reach that goal? There's many statements and much criticism from the German Informatics Society, from AG Kritis, and Dennis wrote something on it. And in general, the consensus is that it's a step in the right direction, but as we saw, it's not sufficient. The 2 points that I talked about are the most important, and there's also other points, as Dennis said. The risks of prosecution and home searches, that's not part of the criminal code, but part of the criminal proceedings code. And this is still a very relevant and present danger. And from talking to hackers, I know that this risk is often the reason why people do not go looking for vulnerabilities, which would be in the interest of the common good, or why they just keep silent about things they found and don't report it. And this really needs to change. And paragraph 202c, which we criticized before, Dennis didn't mention that because this is not slated for change. The question is why? Yeah, okay, it's explained a little bit in this draft, but in my opinion, it should be more clearly understandable to the layperson. And also, as Dennis said, other topics are not mentioned. Business secrets, intellectual property, especially as pertaining to reverse engineering and eavesdropping. Okay, so we have this reform. It's not all good, but at least there is a reform. And what now? I mean, we all know the coalition went bust, the traffic light coalition in Germany. They parted ways, not amicably. And the draft, as it exists now, is not going to pass as is. So the coalition broke up in early November. The government invited comments until 16th of December 2024. And we saw some of those comments earlier. If they're going to change anything, we don't know. And in February 2025, there's new elections scheduled. And new elections means we're back to step one. The subject, computer criminal law, it needs to be put on the agenda again in the first place. There needs to be a new draft developed, and yeah, it's really not clear if it's going to happen at all. But maybe that's not a bad thing, actually, because new elections mean a new beginning, but also new chances to get a new draft to address these criticisms we have better. We're going to stay on it. I've written an open letter with some colleagues, which you find on reform.jetzt, and we're going to keep at it. And Dennis is also going to publish things on it. We're going to stay on it because I, as a hacker, do not want to keep running the risk of being prosecuted for acts that benefit the general public. Thank you.
Thank you so much for this great and very relevant, great talk, very relevant for practice too. So let's have some more applause. So, we even have time for at least one question. Do we have a question from the cyberspace? Yeah. Does this mean if there is suspicion of having a software such as AirCrack and G, is it fair game to search or even seize my computer? Should I answer this? So I think it's a question for the legal background. Generally, owning such a software is not illegal or not a crime. It depends on your intention to abuse it, to weaken cybersecurity, to attack IT systems. If I know nothing about, if I don't have the intention myself to abuse it, then you cannot, do not have suspicion, and there is no basis for seizing something, searching houses, anything. It's different if you can see some deeds showing that there is this intention. Another question from microphone number 1. What is signs for good intentions? that you're not a bad but a good hacker? Do you have to have done responsible disclosure in the past? I asked this to myself. I think if you report quickly what you find, so within like the next day or the next 2 days maybe, then you show your good intentions. And that would be the right step. There is nothing exact written in the law, so it's not really clear. So I think that's a big problem you're showing. We can take a look at the Netherlands and the expertise of the scientific service of the Bundestag. That in some other European Union states we can see some best practices to show this or to prove this good practice. So that there is no investigation immediately started when somebody is disclosing something.
So, hätten
So,
wir noch eine letzte Frage aus dem Netz.
So there's one more question from the internet.
Genau, es ging vorhin
So you talked
Zugangsdaten, wenn man
about
reverse,
access data if you do a reverse binary engineering about access data, but does this also apply in general? Is the binary code also protected, especially? Yes. Yes, we heard about it. We mentioned different levels of culpability. There's general the criminal code and those the marginal law, trade secrets, and if I start decompiling a security, I'm definitely moving in this area of intellectual property and business secrets, and there's even more insecurity and uncertainty than in the core criminal law. And the problem is, on top of it, that intellectual law can't just be reformed nationally, because this is a European law matter, because there's superseding law, and this doesn't foresee these exceptions, because the superseding law is also very, very old. So we don't need to talk to the German parliament, but also to the European Parliament. They've passed some laws, but it needs to be a European matter. Yeah, I can only agree to that. Yeah, and this, dear Dennis, dear Florian, thank you for this talk.